we have to figure out how we're going to use our time. Tonight, obviously, we're going to get through the final deck. We could do another practice question tonight, a substantive review. I think that's a pretty good idea. I like the way it worked last time. I don't know if you guys did. Breaking up into groups, having a leader, that kind of thing. We're in detail.
No, just today I forgot. Thank you for reminding me.
Yeah, no problem. So I think we'll do that tonight. We should definitely have time to do a similar exercise using our new outline for how to do a substantive review question, standard of review question. We'll take a shot at that. It won't be easy the first time, but so we do have the next two classes. There's lots of time to do maybe some more practice questions. I'll see what I can do with that. I want to give you your feedback from your midterm assignment. I don't have it yet, but I'll get those marked as quickly as I can. And I think we'll have time to give you individualized feedback. And I'm hoping to have a guest speaker come in as well, which should be interesting for you. Somebody who's been the head of an administrative tribunal in Ontario. Special secret guest, I don't have the name for you yet. So that could be next week or the week after. We'll figure that out. So it's a little looser now with these last classes. No, that's confidential. A provincial tribunal, not a federal one. Okay. So tonight we're going to talk about, because we have to talk about private law remedies, because sometimes that's the direction you need to go in, although it's really kind of off to the side. It's not the usual thing that you're going to be worried about as an administrative law lawyer. You kind of need to know, get a full spectrum of how to challenge or how to get a remedy when the government has done something wrong to you or your client. So we have to look at that. We're also going to talk a little bit about court venues. And I'm going to give you, you may have seen I've uploaded a court jurisdiction chart because it's actually quite confusing which court you can go in. It's very easy when it's a straight judicial review. Provincial decision maker, you go to what court for judicial review? Yeah, the divisional court. Full name is Ontario Superior Court of Justice, Divisional Court. And then if it's a federal decision maker, where do you go? Federal court. It's not a trick question. And how do you know that?
Statute.
What statute?
Enabling statute. All statutes.
Sometimes, but usually no. The Federal Court Act, or is it Federal Courts Act? I was getting that mixed up. Federal Court Act, Federal Courts Act. Courts plural because there's a federal court and there's a federal court of appeal. So you follow the process there. Generally speaking, judicial reviews, under that statute, judicial reviews go to the federal court. There's some rare cases where you go straight to the federal court of appeal. That's kind of obscure. Not really anything you need to worry about. So provincially, how do you know what court you're going to on judicial review? We name the court. How do we know what court we go to? Were you not paying attention last week? Got a lot of information last week. Enabling statute? No. What's the statute? Anybody? No.
Is it section 96?
People always get these two mixed up.
Is it section 96?
No.
No.
It's Ontario legislation.
Oh, yeah.
What's it called? For judicial review, JR.
Just review procedure.
Right on, Judicial Review Procedure Act. Yeah, the JRPA, which we use as a short form. What's the difference between that and the SPPA? What does the SPPA do again?
That's for procedures.
Yeah, exactly. Procedures for, yeah, pretty much all Ontario tribunals, although not all. Gives us all kinds of procedural benefits, right? In the SPPA. In addition, or sometimes it's the same as the common law, but it's in addition to the common law. So remember that, to keep those two Ontario statutes separate. They do very different things, SPPA and JRPA. Okay, how did I start on down that path? Oh yeah, so we are going to talk about court jurisdiction. So where it gets really weird and complicated is with constitutional challenges. And it's really complicated, but I've tried to simplify it for you with that court jurisdiction chart, which we'll get to later tonight. Okay, so we are going to talk a little bit tonight about, as I said, private law remedies. So sometimes what you're dealing with when you're dealing with the government, you've got a problem with the government, is you're dealing with a breach of contract, or there's been a tort committed by the government of some kind. And there's a couple of torts that you mentioned there that we're gonna touch on. Okay, this is what I was talking about before. Some notes on federal procedure with a federal DM. Generally, you don't need leave to bring a JR. You can just bring a JR. But sometimes the home statute will tell you, well, you've got to get leave from the court. Okay, so you just follow what the statute says. And there's an example of one where leave is required. Do you know what I mean by leave?
Permission.
Yeah, permission to even bring the proceeding that you want to bring. Because sometimes courts want to put a real control, like they want to put a gate on getting into court and not just allow everyone to go into court on everything. So they put a gate, and that's leave to appeal. That's the legislature saying, we don't want to see too many of these. We want to give the court the ability, discretion, to screen out what it doesn't think are important cases, and only hear the ones that are important, significant.
Do you know if anything further happened with Doug Ford and the changes to the Crown Liability, what's it called? Crown Liability Proceeding Act from back in the spring, where they were basically trying to really narrow the ability to sue for breach of contract and negligent contract.
Yeah, I don't have the most up-to-date information on that. I remember hearing about that.
Yeah, so they haven't heard anything.
Yeah, no, I have not.
I haven't.
Yeah,
Okay, thank you.
no problem. Okay, so the Federal Courts Act, again, it's really like the JRPA for us, and they set out, but they approach it a bit differently. So here's the key section is 18.1, where they specify grounds for review. They're all listed there. So they generally align with the common law. So you can bring a JR on procedural fairness grounds. You were denied procedural fairness, of course, just like in common law. And you can also bring a JR on substantive review grounds, like an error of law, error of jurisdiction, these kinds of things, which are, as we understand them at common law, so the substantive review grounds, where you're challenging the outcome, right? So generally, the common law is reflected in the Federal Court Act. And then you've got the remedies, powers of the court that are set out in 18.13, much like the JRPA, has the remedies listed in it for the Ontario Divisional Court. So, in terms of procedural considerations, when you're looking at your options, what kind of proceeding might I take to help my client? Of course, you're going to want to look at what's your client's objective. It could be a new hearing, which is, again, as we have talked about quite a lot, the classic judicial review remedy: quash the decision and get a new hearing. But sometimes your client may want money. Who doesn't want money? But they may want some kind of money remedy. And we know enough to tell our client that with the judicial review, they're not going to get money, right? That might be one of the first things you tell your client. I'm out all kinds of money. I can't practice my profession anymore, and I want that money back. It's an intuitive thing, right? Well, you're going to say, that's not what judicial review is all about. You're not going to be able to get money. But sometimes there's a different way to get money, like breach of contract, for example. Or do you want the decision changed? These kinds of things. We've talked about that. Okay. So which court? We're going to have to roll out the chart in a moment. So which court? The federal court is statutory, has exclusive jurisdiction over judicial review of federal tribunals. We know that. But within the Federal Courts Act, the federal court has some jurisdiction. The Federal Court of Appeal has some jurisdiction. It's divided. But we need to understand that there's concurrent jurisdiction, so overlapping the same jurisdiction between the federal court and the provincial superior courts regarding allegations that the federal government has contravened the Constitution. So this is where it gets weird, because you can go into, for us, Ontario Superior Court to go after the federal government if you're alleging that they've contravened the Constitution in some way, including the Charter. Okay. Maybe we'll take a look at our chart right now. This might be the best time to look at it. Do you guys see it on Boodle? You got it? I don't see it. I'm going to call it out. Why don't I just look at it? Can I look at yours? Thank you. Yeah, so this is as close to perfect as I could get it. So you start off, you look at who's the DM, right? And we're always going to look at the DM. Are they federal or provincial? Do they derive their powers from federal statute or provincial statute? If they're federal, then you go to JR. Easy. The second column. When you bring it to JR, you go to federal court for federal DM. You go to Ontario Divisional Court for an Ontario DM. I've got the statute references there. So if you then go to the right and get more complicated, and these are going to be not very common cases, if you're bringing a JR that's based on constitutional or charter grounds, right, where you're alleging the government has done something unconstitutional, that's part of your JR, you can actually go for a federal DM, you can go to federal court, or you have the choice to go to the Ontario Superior Court of Justice, not the Divisional Court. Okay? And if we go down that column, we see an Ontario DM, Ontario statute. If you're bringing the JR on constitutional or charter grounds, it's easy. You go to the Divisional Court. So it's the same.
The federal one is a choice, so like you can choose.
Yeah.
There's no ruling,
No, that means you can choose the venue. Yeah, you can choose the venue. Okay, if we're not talking about a judicial review, which again is going to be rare, like a tort or a contract proceeding against the government. Oops. Thank you. Again, federally, you can choose. You can go federal court under Section 17 of the Federal Courts Act, or you can go to the Ontario Superior Court of Justice under the Courts of Justice Act. If it's an Ontario DM, simpler, you simply go to the Ontario Superior Court of Justice. And that's in case you're not bringing to JR, but you're suing for damages, suing the government for damages because of a tort or a contract problem. If you're bringing a direct court constitutional or charter challenge to legislation, which we can do, right? We're able to do that. And we're going to see some examples of that coming up. If it's federal legislation and you're in Ontario, you have to go to the Ontario Superior Court. You have no choice. Or Saskatchewan or Alberta or whatever province you're in, you go to that Superior Court and bring that challenge to federal legislation, which sounds odd, but that's the way it is. You got to go to a Superior Court. In Ontario, again, more straightforward. If you're bringing a charter or constitutional challenge to Ontario legislation, you go to the Ontario Superior Court of Justice. Okay? So that's as simple as I can make it in terms of what court you go to, depending on what kind of proceeding you're bringing.
Choice, which one would be better? Which one's faster, simpler?
Yeah, which one's faster, which one's more accessible. Yeah, there are federal courts in Toronto. So it wouldn't just be, we have to go to Ottawa and I'm in Toronto, so I'm going to go, I better go to Ontario court. Well, no, you can actually go to the federal court in Toronto, have the hearing in Toronto. So, there might be different strategic reasons. How long do I have to wait is one of the considerations that you would think about. Okay. So that kind of makes it so that we don't really have to worry about the slide so much. Or that slide. I'm going to skip Telezone. It doesn't really help us that much. It's just an example of a court deciding, or the Supreme Court of Canada deciding which is the better court. But I'm going to skip that. And I'm going to go to our next issue, which is standing. Something else we have to think about. So we've been talking all along about what happens when you have been subject to a DM's decision and you don't like what happened, you, the individual, or even could be a company in some cases. It's very simple. You're affected by the decision, you're involved, you bring a JR, and you seek a remedy, right? So that's what we say. Judicial review is individually focused. It's a way for citizens to complain about unlawful exercises of power. But what about cases, and we do have these cases from time to time, important cases, where there's a bigger issue affecting the whole public, the broad public, the whole public. So an issue of broader public interest, where there's no sort of individual, it's not an individual case about individual rights. So in the old days, the way to deal with that was, we've got an attorney general, and they can bring things to court where there's kind of this general public interest in a legal issue, say around a statute, and we can just let the attorney general take care of those cases. But as you know, as we moved into the modern era, it started to make less sense that we all expect the Attorney General to look after all these kinds of cases, because sometimes just grassroots organizations or public interest groups, they have an issue and the Attorney General doesn't think it's an issue and isn't going to do anything. So how do they get to court? So we have a couple of Supreme Court of Canada cases, 92 and then later on in 2012, that kind of together give us the roadmap for how a group that, like I described, like a public interest group, can bring a matter to court. For example, to challenge the constitutionality of legislation. So again, traditionally the courts would say, well, who are you? I'm not going to hear a challenge from you. You're just some group of people, or you're some individual person. You know, how are you affected by this? Why should we let you bring a challenge in court? What's so special about you? We're going to wait for the Attorney General. Well, the courts started to liberalize this whole question, and they kind of set up a test for whether a group like that could actually have standing. We say to have standing. Again, standing is about, well, who are you? Why should we hear from you? What makes you important enough to bring this challenge? So basically, the initial question that the court says has to be asked is there a serious issue raised as to the invalidity of the legislation in question? And that's usually what we're talking about. Is the legislation invalid on constitutional grounds? Usually that means on charter grounds. So is there a serious issue here? And of course, if you are trying to get standing and you can't convince the court that there's a serious issue being raised, well, you're not going to get anywhere, of course. So that's kind of your initial hurdle. Then the next question is, well, has the plaintiff established that they're directly affected by the legislation? Or if not, do they have a genuine interest in its validity? Genuine interest, what does that mean? Well, again, you can see that if there's a group, say a public interest group, and that's, they're bringing a case forward that engages the rights that they're all about, then that's going to definitely help them make a persuasive case that, okay, we may not be directly affected by this legislation, but we do have a genuine interest in this kind of legislation and the impacts that it has on parts of society. Then the third part of the test, based on Canadian Council of Churches case, is they say, well, is there another reasonable and effective way to bring the issue before the court? So they'll look at that and they'll say, is this really the best way for this kind of case to come before the court? Or is there another better way for that to happen? And if so, if there's another better way, we're going to say no. And let the case come before the court in that other way. But then the downtown East Side case came along in 2012 and even further kind of expanded the ability to get standing, to bring this kind of challenge. And they used this language. So it's kind of like instead of that third bullet, they've modified it, made it easier. And they ask this: is the proposed suit, in all the circumstances, a reasonable and effective means of bringing the matter before the court? Okay, so you can see that's a little easier now. You're lowering the bar in a way and saying, well, if this is reasonable and effective way to bring it to the court, we're going to allow it. Again, as long as you meet the first two hurdles also. So that kind of sums up what the modern test is for what we call public interest standing. Breen was sort of the midway point where it starts to get, the public interest standing test starts to get more liberalized. Okay, here's a joke slide. Yes, you have standing to sue the EPA over the failure to regulate greenhouse gases. It's an old cartoon, very relevant today. All right, got a few minutes. I was looking for, it's not that, it's a little bit funny. It's not that funny. Okay. Okay, so that's a little piece of the puzzle that we need to be aware of, standing. Because you may get a case where, some group comes along and wants to, bring a challenge to court. And you're going to have to look at it and say, well, are they really going to get through the gate? Are they going to be able to bring this challenge? There's lots of groups who want to bring all kinds of challenges, groups, individuals, and a lot of them just don't get anywhere because they don't pass that public interest standing test. Okay, it's a bit of a mixed bag today. We also have to talk about this. So, when you bring a JR against a DM, is the DM there in court? That's the question we ask.
Not necessarily.
Or are they there with a lawyer, represented by a lawyer? Seems weird, right? When you go to, let's say you go to court in Ontario, Superior Court, you get a decision, then you appeal it to the Court of Appeal. Does the lower court judge get to go and sit there and have a lawyer representing, saying, I was right? Weird, right? Yeah, you can see head shaking, like that doesn't sound right at all. But again, administrative law being weird, and cool it away. I don't know what you guys think. The DM, in general, the DM is actually allowed to be there to defend its decision on judicial review. As strange as that may sound to us, that's kind of the way the system works. And I'm very proud to say that the Goodis case was a critical case in this. Yes, that is me. Okay, so let's start with the starting point. Traditionally, the courts, and this is the Supreme Court of Canada in 1979, said, well, we're going to let a DM, a decision maker, be there on a judicial review, but we're going to keep them on a really short leash, right? They can only speak to very limited questions or issues. They're not like a full-blown party. So yeah, here, they're not a party. Their role is merely to explain the record. So maybe just explain some key thing that happened at the hearing that's in the record of the whole hearing. So very limited, otherwise it's like sit down and be quiet. That's your limited role. As we got into the 80s, that started to evolve a little bit. Then we had the Goodis case from, I didn't put the year, 2005 or something like that. I don't remember now. In the 2000s, so not that long ago, in Ontario, divisional court, there's a challenge to my ability to have my lawyer there defending me. Yes, that's true. So happened the Ontario Attorney General wasn't very happy that I was allowed to have a lawyer there to be very involved and to make strong submissions defending my decision. And this actually went to the Court of Appeal. The Court of Appeal agreed with the divisional court and said, yeah, Mr. Goodis is allowed to have a lawyer there. He does have full standing rights. And they based this largely on the JRPA, which says that the decision maker may be a party of the JR. That's what the legislature said. So yeah, I'm entitled to be there. I'm entitled to have a lawyer. So that reflects the more modern approach in Ontario. But it doesn't mean that, there are some restrictions on my lawyer's ability to fight the case. We have to be careful about being too partisan and sort of attacking one side or attacking another side, that kind of thing. But basically, we can act more or less like a full party.
Is this the Ministry of Correctional Services?
Yeah. Yeah. What year was that?
2006.
Maybe it was close. Okay, thank you. So it's something to be aware of. It's not a huge issue for you, but something just to be aware of. Okay. Remedies. We need to think a lot about remedies because it's part of the picture, right? Again, we were saying earlier about what does your client want? What do they expect to get? What do they want, and what are you going to tell them? Oh, hey, I can try to get you this, but I'm not going to be able to get you that, or this is what we're going to try to do for you. But here, your client needs to understand the limits, so you've got to explain that to them. And even in deciding which way are you going to go, are you going to try to get money, which is a different thing, or are you going to try to get a new hearing or get the decision overturned? These kinds of things. Okay. So we're kind of back to the first principles of judicial review, but we start off and say, and this is a reminder, we've talked about this before, if there's a statutory appeal of a DM's decision, which you will find in the DM's home statute, pretty much you always have to take that, right, before you bring a JR. If you don't take that, you try to bring a JR, they're probably going to tell you, you're in the wrong court, you've taken the wrong proceeding, you have an appeal in the statute, take that appeal. Okay, but we know that in most cases there's no appeal. So we bring a JR under the JRPA or the Federal Courts Act. And we know about the JRPA in Ontario, we know about the Federal Courts Act, we talked about that. So I'll go to the last point here. One thing you always have to keep in mind is that a JR application generally does not have the effect of staying the underlying process. I think we mentioned that last week. So you kind of ask the DM for a stay, which they will usually give in normal circumstances. The tribunal can choose to stay their decision as a courtesy. Modern legislation allows the courts to make interim orders such as stays, and sometimes the DM, for whatever reason, won't stay their decision, so you have to go to court, and the court will apply the Manitoba Metropolitan Stores test for the application of a stay, which is like, I don't know if any of you are familiar with an injunction. When you want to bring an injunction, there's a test for kind of weighing the pros and cons of granting the injunction or not granting the injunction. And they do a similar thing based on this Manitoba case in terms of whether they're going to apply a stay or not. Most of the time in a JR, they're going to grant a stay, most of the time. So that's the Manitoba Metropolitan Stores case. And here's the test, again, which is a lot like the injunction test in any court. So one, is there a serious question to be tried that it's not, and as opposed to not being a frivolous or vexatious question or challenge. Two, irreparable harm. In other words, is there going to be irreparable harm to the applicant if you don't grant the stay? And then three, what they call the balance of convenience, which is court has to take into account the pros and cons of granting the stay or not granting the stay. And here they will consider the public interest, not just the interest of the immediate parties, but the overall public interest. So they're going to look at the whole circumstances, the landscape, and decide whether it's better to grant a stay or to not grant a stay. And it so happens in the Manitoba case, they refused to grant a stay, and that was upheld all the way to the Supreme Court of Canada. And there's this idea that they thought, well, if we grant a stay, it's going to put the entire labor relations scheme at risk, so we're not going to give the stay in that case. Okay. We touched on this last week. We're going to take a much deeper dive into it. We're going to spend quite a bit of time on this, and practically speaking, it's really important for us to understand both at the Ontario Divisional Court and at the federal court in a judicial review. There's a lot of discretion in the court as to whether they're going to grant you the remedy that you're looking for. A lot of discretion. And we need to think about this, because you may have a great case. You may have a really good procedural fairness case to bring, that you were denied procedural fairness, and you may also, or as an either or, have a really good substantive review case to make. But despite that, again, a challenge for us as admin lawyers is you may get the court saying, yeah, way to go, really good case, but we're not giving you what you want. Oh, okay. And you can't come back with, oh, but you have to give me the relief. They're going to say, no, we don't. You need to understand that judicial review is discretionary, and we don't have to give a remedy if we don't think it's appropriate. Again, even if you have a great case to make on fairness grounds, on substantive grounds. Okay. So we need to look at, well, what are the pitfalls here? What are the situations in which, I might be hit by one of these arguments that I shouldn't get the relief that I'm looking for? And so we kind of sum them up here. This is a good slide because it kind of gives you the whole landscape of what you need to worry about as far as maybe being told, no, we're not going to give you the relief that you want. So we look at adequate alternative remedies. Basically, is there a better way for you to go to get your relief? Sometimes there is. Are there alternative methods to establish your rights or enforce orders? Is your case premature? That's a biggie. Premature, talk about that. Is it moot? We mentioned it last week. We'll go back at it again. So the opposite of premature. Have you waited too long? Have you waited too long to bring your case? Delay. Collateral attack. We'll see what that means. Clean hands. Are you coming to the court with clean hands or not? Have you been badly behaved or not? Waiver. We'll talk about what that means. And then balance of convenience. That last point we'll explain later. Okay. So to the first one, adequate alternative remedy. We say that party must exhaust all other adequate means of recourse for challenging the DM's actions. This means, for example, if there's a reconsideration in the statute, what does that tell me? If the legislature puts in a reconsideration right in the statute, which they sometimes do, not always, what does that say?
Of course, you have to ask the DM to reconsider.
Yeah.
There could be reasons why it's just different.
Yeah, it's a strong signal from the legislature that they want people like you who are upset, feel aggrieved, to try the reconsideration process. Doesn't mean you have to. But again, the court, if you get in there, there's a reconsideration, and you didn't bother with it, you didn't try it. Again, the court, in its discretion, is going to say, we can hear you, but we don't understand why you didn't try reconsideration first. Tell us why you skipped that step. You better have a good answer. Chances are you're not going to have a good answer. And they're going to send you back, say, try it. It might work. It's right there in the statute. Try it. Okay. Obviously, again, respecting the statute, if there's an internal appeal or a statutory appeal available, you got to take it. Again, as written in the statute. You pretty much have to take it. Again, technically, you don't have to. But you know that that court on judicial review is going to be very aware of it, and they're going to ask you, again, why you didn't take it.
Is this one of those places, again, where the forever limited court resources come into play, and they say, we had, or you had that alternate, whatever.
Yeah. Yeah,
And now you're wasting
exactly.
our time and other people don't get the space because of you.
Right, and we know that, we hear about limited court resources. The courts are going to be very upset if they feel that you are wasting their precious time when you could get a remedy much easier without having to go to court, which we know is more expensive, and they think of their time as being more valuable than others, like a DM.
Are those factors going to just the fact of which remedy you get or you don't get, or it might also affect the fact that they won't even review the
Yeah, so you can try to be creative. You can say, well, they're not going to be able to give me the remedy that I want because I want some special remedy.
But I mean, they'll
So-
consider those factors, like they'll consider if you didn't do whatever consideration or didn't appeal, that they might not give you because of that.
Yes. Yeah, they might tell you to just go away, like right away. Right away, as soon as the hearing opens, they might say, we have a question before we proceed. We see in the statute that there's a reconsideration. We see in the statute there's a statutory appeal. Why didn't you take it? The other scenario would be the other side brings it up. Right, so they raise it. So obviously it becomes on the
They
table.
might give them no remedy at all. They might just say we're not going to review it.
Yeah, no remedy or not even have a hearing, right? So yeah, I get that question a lot. So it's either we're just not going to give you the remedy. In a case like this, it would be more like we're not even going to hear your judicial review arguments at all. So again, on day one, on the morning of the hearing, at 10 a.m., when the judges come in, the first thing they're going to say after good morning is, what are you doing here? Why are we here? Why are you taking our time? There's an appeal. There's a reconsideration. Why did you not do that? And this really happens. This actually, I've seen it happen. And sometimes the lawyers are caught off guard. They shouldn't be surprised. Sometimes they will have a good explanation. And the judges might grumble and say, well, you make a good point. Okay, fine. We'll hear you. So, it's up to you. But you would never want to go into court not having taken a reconsideration or taken an appeal without a really good reason. And you may have one. You may say, well, court, only you can give me the relief I want, which is X, I don't know, declaration or something like some kind of relief that you say, that DM can't give me that. Something of that nature. But again, that's going to be really hard for you to convince the court that you were being reasonable when you just skipped a reconsideration step in statute. They're not going to be impressed.
So if you lost the deadline for the appeal, is that a good explanation why?
If you
lost the deadline, there was a specific deadline for the appeal. So is that something that
you say, well, I was late.
yeah.
I guess, but they would say, well, did you ask them to waive the time? But yeah, it could say, that's a good point. Let's say the statute says you can ask for a reconsideration within 30 days. We have something kind of like that. In our rules, it's not in the statute. And you say, I missed the deadline, oops. So that's why I'm here. They'll probably say, well, did you ask them to waive the 30-day period? And maybe if you did, good, because if they said, yeah, you know what, it's day 31, you're out of time, we're not here with you. So then you go to court and you say, I'm sorry we're here, but we tried that and we failed. We couldn't do it. Or an appeal. Yeah, lots of appeals have a 30-day or 60-day or some kind of, relatively short deadline. Yeah, and if you miss that, it's a bit embarrassing, but if you miss it, you miss it, and maybe, you're at the end of the road. So you have no choice, which would put you in a better position. They might reluctantly hear you.
But in a situation like that, if it's 30 days to appeal and you show up until 31, and they say, too bad, haha. When that gets to the court, the judge is going to say, sharp practice.
Yeah, they may not be impressed with the DM for being so technical.
Sticky, yeah.
Yeah, and not just saying, well, you should just waived it. They
Yeah.
didn't come a year later
Yeah, okay.
where you could say, okay,
Yeah.
well, that's reasonable. But if it's day 31 of the 30-day, they might say, they really should have been more generous and waived the time period, if they're able to. Depends on the statute. Are they able to or not? It's a good question. Okay. So bottom line, of course, here the court has discretion. They can hear you anyway if you have a good explanation. But you could very much be in trouble here and not get what you need from the court. The Herelkin case, University of Regina, Supreme Court of Canada. Okay. So remember the phrase adequate alternative remedy. What does the word adequate mean to you? Sorry? Yeah? Sufficient, adequate?
Meaningful. Like that you can get a meaningful decision there, that it's not just lip service.
If somebody talked about you as being adequate, what would you think? It's not very complimentary, is it? Yeah, so-and-so's adequate. Yeah, so my point being, it's a low bar and the court will say, is it good enough? Doesn't have to be perfect. So, in other words, this is a signal, the court saying, don't come to us and say, oh, but you, Corey, you're so much smarter than these dummies. I don't want to go to them. What do they know? You, in your infinite wisdom, court, I'm here before you because I know you, court, again, in your wisdom, are going to give me a better hearing and a better remedy. Well, the court says, no, we don't like that talk. As long as the other remedy or the other remedy that you're seeking or the procedure that that you skipped over, as long as it's adequate, the court says that's good enough for us. It's not about which is better. If the other one's adequate, it's good enough, it's reasonable, that's the way you should go. So here, Mr. Herelkin was a student who was required to withdraw from the university. So he tried this. He said, so he gets this appeal. He was required to withdraw. He appeals. His appeal was dismissed. But what he did was he skipped over, he had the statutory right of appeal to a committee of the university senate. It was right there in the statute. He said, for whatever reason, I don't want to do that. I want to go to court. I'm bringing a JR. And I think he tried something along those lines to say, well, I'd rather go to court than some committee of the university senate. Because the court's better. The court had no time for this. So this went all the way to the Supreme Court. And he said, no, that is disrespecting the legislature's intention. They put it in appeal to another DM, granted, not a court, another DM, and you have to take it. And again, we're not going to entertain any kind of argument that, oh, well, the courts are better, that's why I'm going to court. So the court looks at the appeal mechanism under the statute. Again, appeal to a committee of the university senate, good enough, adequate. It's adequate. You can get what you want from that DM, so that's where you should go, and we're not going to hear you. Yeah, I don't think this case is as helpful. It really illustrates a similar point. What we learned from Matsqui is this. What are the adequate? So when we're analyzing what's an adequate alternative remedy, these are the factors the court's going to look at. The convenience of the alternative remedy. So is it convenient or inconvenient? The nature of the error that we're talking about, the nature of the appellate body, what kind of body is it under the statute that would deal with this as the alternative remedy? Is it investigatory? Does it make decisions? What kind of remedial capacities? So in other words, you could say, well, that alternate remedy, that other DM is not good enough for me because I need something better. It's not adequate. I need something better. For example, the kind of remedy that I want, which only you, court, can give, this DM can't give it. And then the court will keep an open mind and say, okay, you may be able to persuade them that the other remedy is in fact inadequate, and then good for you because then the court will hear you. So again, we say the question is not which one's better, but is the other avenue adequate? And again, you may be successful on that. It's possible. Again, in this case, the alternative remedy was adequate, and it was adequate in Herelkin. So you can see, it's not going to be easy, but it's possible. Okay. Prematurity. So, we can spend some time on this idea that you can't go to court until what they say, the administrative process has run its course. Right? Because technically what we teach and what we understand is you can always bring a JR at any time. Technically that's true. You can bring a JR at any time. You can go into a hearing and then after 1 hour of the hearing, you hear something you don't like and you run off to court. You can technically do that. But you run a very high risk that the court's going to say, why are you here before the DM has finished their process? They just got started, or they're halfway through, or they haven't finished. Why are you here? You're wasting our time. Let the DM finish their process. So once again, if you're going to the court before the DM has finished their process, you better have a good explanation for why you're there prematurely, why you're there early, because they're going to want to hear that. And they're going to want to be convinced as to why they shouldn't tell you to go away, go back to the DM, and let that process finish. So we say that the courts are very strong on this. They say we are not inclined to interfere or should not interfere with an ongoing administrative process until after the process is completed or until the available effective remedies are exhausted. Makes sense, right? So, digging down a little bit. So why is this important? Aren't the courts there to, give justice, and if something bad happens partway through a DM's hearing, then why shouldn't the court intervene and fix the problem? Don't we want that? Well, here are the reasons why, what the courts over time have said, why they've said, we're not going to intervene in the middle of a case. Except in very rare circumstances. They say, we don't want to see the fragmentation of the administrative process and piecemeal court proceedings. You can imagine, in a case, let's say the parties have, or a party has unlimited resources, big company. They bring a JR halfway through. They lose. They go, okay, we lost. And then the hearing continues. Something else bad happens that they don't like. They bring another JR. Then they lose again. Then they bring another JR, and they slow this down. You can imagine a party with a lot of resources could say, we're going to tie this thing up in the courts forever. We're going to make sure that it takes like 10 years for the DM to finish their hearing. Of course, the courts do not like that. They want to see that the legislature's choice is respected and that a DM is allowed to finish their hearing that they started. Yeah, and they think about the large costs and delays associated with premature forays into court. Again, knowing what we know that a JR can cost $25, $50, $75, $100,000, right? The cost is enormous, and the last thing we want is like proliferation of JRs, multiple JRs in one case. We don't want that. And there's also this pretty obvious point that parties that complain, oh, this was unfair, that was unfair, I didn't like what happened. Well, they may win at the end of the day, right? So it doesn't matter. You could be subject to a really unfair DM hearing and still win, right? It's possible. People are can be surprised that way. So the courts say, again, when you come partway through, they're going to say, okay, I hear you, you're saying this is really unfair. How do you know you're going to lose? Oh, we're convinced we're going to lose. Well, no, you don't. You don't know you're going to lose. So keep going, let it run its course. You may win, and then everyone's happy because no one ever has to go to court. Right? And you don't, again, waste the court's precious time, and waste all that money and time in bringing and hearing a JR. So yeah, they may succeed at the end of the day. So let the case run its course. Also, the courts say, look, we don't want to weigh in until we see the whole picture, right? Start to finish. What happened in this hearing? Again, procedurally or, of course, substantively, when the decision comes out, courts say, we are comfortable looking at an entire process. Procedure, outcome, reasons. That's what we do. We're not comfortable looking at a piece of a process that hasn't even finished yet. And let's see the decision maker's findings, because they, of course, may shed light on everything that happened. So that's the best way to approach it, say the courts. Yeah, and we want to hear what the DM has to say, because the DM may weigh in on this dispute that they have with the party. So the court says, oh, we're now going to get the whole picture, including what the DM has to say. Now we can make a proper decision, not partway through. Consistent, and this is consistent with the Dunsmuir deferential approach to judicial review, right? Hands off, in most cases, let the DM do their thing. Only at the end will we consider intervening. Not in the middle. Okay, the Howe case, Ontario Court of Appeal. So this is an example of a party saying partway through, we don't like what happened, we're going to bring a JR. So the Institute of Chartered Accountants of Ontario, they carry out an investigation of Howe. There's a disclosure issue. They disclosed some material to Howe, but they withheld a key document, which was the investigation report. They said, we're not giving that to you. So Howe says, oh yeah? Well, I'm going to court on that issue, because you should have given me that report. So Howe JRs the decision to deny access to the report, which again, let me emphasize, you can do. Again, technically, it's a decision of a DM. It's an interlocutory decision, but you can't JR, right? No one can tell you that you can't bring a JR. And wow, look at this. The divisional court refused to intervene, so they did what we would expect them to do. Howe says, all right, I'm going to the Court of Appeal. How many years did Howe buy here in delaying the whole case, right? I guess Howe had the money to bring a JR, lose, appeal to the Court of Appeal. So it goes to 3 judges of the Court of Appeal. And there was actually a split, but the majority said what we would expect them to say, which is that this case is premature. We're not going to intervene in an interim matter, except in rare circumstances. And the majority said, look, we're assured that there would be an opportunity for a full review at a later stage, which was the statutory appeal. So they said to Howe, basically, you may have a really good argument. And it may be the case that you should have got this investigation report, but again, you're here too early, let the case run its course. Who knows how this is going to turn out? So based on prematurity, we are not going to intervene, says the majority. I guess there was one minority judge who really didn't like what the DM did here and wanted to intervene, had sympathy for Howe, but that didn't win the day. Okay, here's a good one. This is always fun. The Air Canada case and Lawrence. So this was it's a labor case, an unjust dismissal complaint under the Canada Labor Code. An arbitrator is appointed. The hearing starts, and poor Air Canada, through the DM's or the arbitrator's behavior, they decide, well, we've got a reasonable apprehension of bias here. We've got an RAOB here, 5 days into the hearing. Obviously a big, complicated case. There's an RAOB. So Air Canada, what do? They ask the arbitrator to recuse himself. The arbitrator says, no, I'm not recusing myself. There is no RAOB. Air Canada runs off to court on judicial review. So what does the court say? And this surprises a lot of people, what the court said. They think the court was pretty harsh here. The court said, Air Canada, here's what you should have done. You shouldn't have come to us. Here's what you should do. And we should learn from this. They say the application's premature. Air Canada, what you should have done is once you asked the arbitrator to recuse, that was a good thing that you did. It's the right thing to do. The arbitrator said no. What you should have said is, then, instead of coming to court, you should have said, well, we are putting our objection on the record. We still think there's an RAOB, with all due respect, but we are prepared to finish the hearing, despite what we think is an RAOB. So put that on the record. Finish the hearing. Again, Air Canada, you might win. You don't know. Of course, they're thinking, oh yeah, we're screwed here. We're going to lose this case. So what, says the court? So what? You may be right. You may be wrong, you may be right, whatever. Finish the hearing, then come to court and bring your RAOB challenge. And maybe you have a really good challenge, but bring it at the end, not in the middle. No matter how good a case you think you have. Just finish. Now, the court did say that's not always going to be the case, but that's the case here. So they say, well, these are the factors to consider as to when we'll decide it's premature or not premature. We're going to look at whatever hardships are going to be caused to the applicant, including waste if there is a bias found. So were they forced to go through a big, long, biased hearing? Okay, we're going to think about that. But again, we also don't like delaying the administrative process. We want it to run its course quickly, and we don't want multiplicity of proceedings. So half a hearing, JR, hearing starts again. We don't like that. We want to avoid that. Again, all the things that we've been talking about. We kind of went into this last week, didn't we? Mootness. What was the example I brought up? Anybody remember?
If the jockey or whatever was retired and said, well, I'm already retired anyway, so I don't care. I just want on principle to get my license
Yeah,
reinstated.
exactly.
Yeah.
The jockey who says, well, I'm never going to race again, but I want my license back. Really? To do what? To put on the wall. Proudly have it hanging there, and I still have my license. I'm never going to race again. But it's a case of principle. We can laugh about it, but there are situations where somebody would say, hey, this is my reputation. So this does matter. Anyway, so we've got this idea of mootness, and we definitely need to think about this because there will be cases where the outcome doesn't really matter. And the court's going to be aware of this, and they may decline to hear a case that raises only hypothetical or abstract issues that aren't real, real and practical, and don't have a real world impact. So a case is moot if it will have no practical effect on the rights of the parties. But we know, and if you're dealing with a situation where mootness is a problem, you've got the Borowski case, it's referred to in our book, because the court may exercise its discretion to hear a moot case. And there have been cases like this where they say, well, you know what? This case raises important legal issues beyond the interest of our jockey friend. Maybe it raises issues for other jockeys, right? As to how the Ontario Racing Commission handles its disciplinary cases or something like that, where you can argue that, yes, it's moot, you might admit that it's moot, but court, you should hear it anyway, and here's why. So you can try different approaches to convincing the court to hear a moot case, but you're going to have an uphill battle. Okay, again, revisiting a little bit what we talked about last week, delay. We know that in Ontario, Ontario, there's no time limit, right, to bring a JR. So you don't have to jump in there after 30 days, or within 30 days, no time limit under the JRPA. Federal court's different. Parliament decided when it wrote the Federal Courts Act, that it wanted a time limit, a 30-day time limit from the communication of the order. So that does have the effect, well, puts more pressure on lawyers to act quickly, and does have the impact of sort of automatically screening out late JRs. So there's that natural control. So you really need to be aware of this when you have a federal DM. Just remember, when you have a federal DM, the clock is ticking as soon as you become aware of the decision. And that 30 days is going to go fast. So we have the Friends of Old Man River case from Court of Canada. So leaving aside the statute, we have the statutory 30 days. Well, let's say it's Ontario. There's no time limit, and you bring a JR a year or 2 years or 5 years after the DM's decision, you may have a problem. And we know from this case that an unreasonable delay could bar an applicant from obtaining a discretionary remedy, particularly where the delay, and this is key, where the delay would result in prejudice to other parties who relied on the challenged decision to their detriment, right? So there's this idea that once a decision made, that's the law, that's kind of the last word. So we don't want situations where decisions made, the parties rely on it, they act accordingly, and then way down the road, there's like, oh, well, hang on a minute, there's now a JR, so that decision could be, overturned. So the courts don't want to have a scenario like that where parties could be harmed by way of acting on a decision that could get overturned way down the road. So in this case, the Supreme Court of Canada ended up saying that the trial judge was incorrect to refuse relief on the basis of delay, as it happened on the facts of that case. But yeah, it's just going to come down to the situation that you're in, and you're going to want to look at what's the impact of the delay. If the court says, yeah, we know the decision was made 5 years ago, but we're happy to hear it, well, how would that could harm some parties. So you have to look at the context, the circumstances, and you can imagine a scenario where, again, years down the road, if a decision is overturned, that could cause real prejudice to people. Okay. Okay, this one's a little complicated. Collateral attack. Interesting one. not going to come up a lot, but let's have a look at this case because it'll help us understand what we mean by collateral attack. It's a little bit related to delay, but not really. So there's the Consolidated Mayburn Mines case, Supreme Court of Canada. Bit of a complicated fact scenario. So here's what happened. A director with the Ministry of the Environment in Ontario issued a cleanup order under the EPA, as it then was, Environmental Protection Act. So they issued this order to clean up against this mining company. In the statute, there's an appeal from an order of a director of that ministry. You can bring an appeal to a thing called, I don't think it exists anymore, but the Environmental Appeal Board, right? So that's bringing a statutory appeal from a DM to a higher DM. And then there's another appeal from that board to the divisional court. Again, written in the statute. So what does the mining company do? They just don't do the doing a cleanup like that was probably very expensive. They say, yeah, we're just not going to do it. And they just ignore the order. But they also don't appeal the order. They don't seek a JR. They do nothing. Well, the Ministry of the Environment is aware of this, that the mining company did nothing. So they say, well, we're now going to prosecute that company under the EPA because there are offenses under the EPA for failure to comply with an order. So they bring this prosecution. Well, they can't ignore that because there's some pretty serious consequences of failing to comply with an order. So then the company sort of comes to life and they say, well, in that prosecution, we're going to attack the order and we're going to challenge the validity of the order in the course of the prosecution. So you can see how, they're trying to attack the order in an unusual way. In a way that the legislature did not intend. Why did they put in those appeals? And right there in the statute. That's not what they intended to happen in a case like this. Right? They intended for parties to appeal in the proper way. This goes all the way to the Supreme Court of Canada, and the company says, the Supreme Court of Canada says, the company cannot now challenge the validity of the order in this way. This is a collateral attack on the order, which undermines the integrity of the administrative structure and its appeal mechanisms. Right? So we may be clever lawyers, and maybe they had a clever lawyer who thought, he or she was giving good advice. This is the right way to go. But we as administrative law practitioners would say, wow, you're really playing with fire when you ignore the statute and you ignore the procedure in the statute. You're playing with fire and you're probably going to get, you're probably not going to succeed at the end of the day. The courts are not going to be impressed. So you need to respect the legislature's intention, respect the statute and the procedure in the statute. So not a surprising outcome at all. But you can see it's an unusual situation where they were able to launch this, what they call a collateral attack. Oh, we're over an hour in. Who's tired? Should we take a break? I'm kind of in the middle, but we don't have a huge number of slides tonight. So let's break till 7:30 and come back and look at this. Again, reasons why the court may use in its discretion, right, to refuse to grant a remedy or even to hold a hearing that you're asking for. So another one of these grounds on our checklist there, which you want to have handy, is misconduct of the applicant. So we talked about HomeX earlier, back in the procedural fairness days when we were talking about procedural fairness. And it's an older case, but this is a case involving a procedural fairness problem, and the court actually did conclude that HomeX was denying procedural fairness. They did have a right to be heard, and that was denied. But the court says, yeah, but we have discretion to grant a remedy, and we're not going to grant the remedy. We don't think they're entitled to their remedy because of all the bad conduct by HomeX in the entire proceeding. They said, you acted in ways that were, contrary to the public interest. There's all this bad conduct that resulted in a very protracted hearing, and we're not going to award that kind of bad behavior by granting the remedy that we would normally grant to a party that didn't engage in this bad conduct. So we're going to refuse to grant the relief. So again, you can see how even in a case where you've got a really good, again, procedural fairness argument that you were denied procedural fairness, but the court is not going to give you the remedy that you seek, the relief that you seek on judicial review on this ground, misconduct of the person bringing the JR, the applicant. Okay, waiver or acquiescence we need to talk about. So this is back to our RAOB, Air Canada, the Lawrence case. So imagine another scenario where, like, let's say Air Canada becomes aware that they have an RAOB, or they believe they have a reasonable apprehension of bias in their decision maker, but they don't say anything. They don't say anything. They sit quietly, they don't raise it. And then they lose and they say, okay, now we're going to bring a JR, we're going to make our RAOB argument. The court says we don't like that. That's called, they use this funny expression, lying in the weeds. I don't know where that comes from. Lying in the weeds, meaning you sort of you hide yourself, you don't say anything, you don't raise it, and then you raise it up for the first time on judicial review. The courts don't like that. Why would they not like that?
But, so if I were a representative of Air Canada, would I raise it to the DM?
Yes.
That I think you DM have a
Yes.
RAOB?
Yes.
That's so weird because
Yes.
I think if I were in the DM's shoes, I would get offended and I would like, the ruling might be worse than it would be initially.
Was it because they're wasting the court process and the time, which they could have resolved it at a much earlier stage?
Yeah, exactly. That's the exact point. So, you risk offending the DM, but you're taking a bigger risk by not raising it with the DM because the DM can fix it. They have the opportunity to fix it. And guess what? In a lot of cases, the DM will recuse themselves when you raise it. They might do so reluctantly. They might be angry or upset about it, but they might do it. They might recuse themselves. Then you solve your problem. And the court never had to be involved. This happens all the time. It's a real thing that happens. So your job as an administrative law lawyer is to be brave and tell your client to be brave and say, we got to raise this. We cannot be quiet about this. This is a serious matter. We have to bring it to the attention of the DM. You can couch it in all the respectful language that you want, but yeah, the fact of the matter is you got to take it on with the DM. And you got to present your case of RAOB and say to the DM, what are you going to do about it? We're asking you to recuse yourself. Please recuse yourself. And they have to make a ruling. They can't just say, well, I'm not going to deal with that. The DM has to deal with it. When it's put to them, they have to deal with it. They may recuse themselves, they may not, but either way, at least you've brought it to the DM. The DM's had an opportunity to weigh in on it, to say, yes, there is an RAOB, or no, there isn't an RAOB. They're going to give reasons. And then if it doesn't go your way, you're going to have those reasons, and the court's going to have those reasons in front of it, if and when there's a JR.
How frequently would you say, ballpark, the DM in one of these, in one of these is actually called an arbitrator? Because that's part one of the question, and part two.
How often do they call themselves
Like,
an
is
arbitrator?
that frequently the title that they're given? Because my next question is, do they ever yank in the Arbitration Act to say, because it's got language about bias and removing yourself and all of that. So do they ever
Yeah.
link those two things?
Yeah, if you're an arbitrator acting,
Like in labor law, it's also.
using your authority under the Arbitration Act, like in labor law, yeah. Yeah, definitely. Most DMs don't call themselves arbitrators
Right.
in our whole world of, they have different titles. We looked at that. Sometimes they're called adjudicator, referee, board of inquiry. They have all these different names,
Okay.
titles, hearing officer, these kinds of things. Yeah, if they're exercising powers as an arbitrator under the Arbitration Act, or Arbitrators Act,
Yeah, whatever.
I forget what it's called. Yeah, they're gonna,
So they will yank.
they and you want to follow the procedure under that act, raising an RAOB, but otherwise at common law, you bring it up, use your common law, and get a ruling. That's the bottom line advice here or guidance here on RAOB, because otherwise you're going to be faced with this problem when you get to court. Why didn't you bring it up earlier? And it's not a good answer to say, oh, we didn't want to offend the DM. It's just not a good answer. Not going to buy that. They're going to say, your job is to be brave and raise an issue on behalf of your client that's a serious issue, and raise it at the earliest opportunity and not lie in the weeds. Do not lie in the weeds. It's very uncomfortable lying there in the weeds. Don't do it. So the courts are saying to us loud and clear, not to do that, but to bring it up at the appropriate early stage and not wait till you get to court. Okay, I think this is the last one that we talked about, which is balance of convenience. So this is the idea that the court will say, well, okay, we've heard the case, we've heard the arguments. Should we grant the remedy or not? And Mining Watch is a great example of the court being really torn as to whether it is a good idea to grant the remedy or not, because granting the remedy could cause a lot of harm, in this case, financial harm. On the other hand, not granting the remedy, maybe that's could cause harm in a different way. So they look at the balance of convenience, the impact on the parties and the public of either granting the remedy or not granting the remedy. So let's look at what happened in Mining Watch so we can understand a real world example. So in this case, the federal government screwed up, made a mistake by omission, and they failed to carry out a full environmental assessment of a particular project. It was pretty clear in the statute they were supposed to do it. For whatever reason, they didn't do it. And this organization called Mining Watch, a public interest group that's got environmental concerns, in particular around the process of mining that goes on in the country and what harms it can do to the environment. And they bring this case, and they have a really good case, and they argue to the court that the government dropped the ball. They should have done what they are supposed to do under the statute, and that is carry out this full environmental assessment. And we know environmental assessments are a big deal, right? And they can be complicated and expensive, and they can take a long, long time, years in many cases. So, the Supreme Court agrees with the lower court that this decision was made without statutory authority. The decision to approve this project. The lower court directed that the full assessment be completed, which you would say, well, that seems, of course, like the right thing to do, because that's what should have been done under the statute. Makes a lot of sense. But the Supreme Court of Canada says, well, not so fast. even though intuitively that seems like the right remedy, we're not convinced that it is the right remedy in the circumstances. And they end up saying, well, the right remedy here is to declare the action invalid. It's legally invalid because the federal government didn't follow the statute and carry out the assessment they were supposed to do, but nothing further. Just make the declaration. So why is that? Well, they looked at all the factors, like I was saying. They looked at, what were the goals of Mining Watch in terms of ensuring the federal government carries out its appropriate role of doing an environmental assessment. They looked at the conduct of this company called Red Chris, who was the company that was doing the mining project. The court ends up saying, well, the goals of Mining Watch were certainly legitimate, and they could be achieved in a way that would not impact Red Chris so significantly. They said the financial impact on this company would be so severe as to be kind of out of proportion. It wasn't their fault that the government failed to do what it was supposed to do. So they said, we're going to let this one go, but we're going to make a declaration that's forward-looking. So Mining Watch kind of achieves its goal by having a court, in this case Supreme Court of Canada, say this is not proper. The federal government must carry out its proper statutory duty in these kinds of situations, in these cases. So it's kind of a looking forward type of remedy without so harming this company that they would in effect go out of business. So that's how they balance the rights and interests that were at stake here. We can read that case and see if we agree or disagree, but they carried out that kind of balancing. And they said, ultimately, the balance of convenience does not favor forcing Red Chris to halt their project, let the federal government come in, maybe spend years doing an environmental assessment and effectively killing a company and causing all that kind of monetary harm. So they're going to look at the balance of convenience and the impact of granting the remedy versus not granting the remedy, the interest of the parties, the public interest, all of that. Okay. So we hinted at this earlier, the idea of a money remedy. Okay, there's different potential ways of obtaining a money remedy in our world of administrative law. There's this idea of, well, if money is mistakenly paid to a statutory authority, that money can be, a decision can be reversed, so the money's paid back. There can be circumstances where JR leads to a monetary remedy. Yeah, mandamus requiring a DM to pay already allocated money in accordance with an existing statutory duty. These are all very unusual, obscure situations. But there's tort liability, which is bigger, more examples of this, where the government has committed some kind of tort against an individual or a company, and you can seek a money remedy for them, not through judicial review, but through a tort proceeding or a contract, breach of contract kind of proceeding, for example, not jail. So I'm going to skip that slide. Money remedies through judicial review. It's so rare and unusual that it's not worth spending much time on. But we do need to talk about tort liability. So the government can be liable for an unlawful administrative action or inaction, but we have to think about how we ground this kind of tort action. It has to be grounded in a known, what we call a head of tort liability. But we have this example, the Roncarelli and Duplessis case from 1959, Supreme Court of Canada. This is the idea of where a government authority takes some kind of malicious action against somebody, and they use this term malice, and this is going to be a possible tort action for you if the government has acted in a way that fits within the concept of malice. And they describe it this way: simply acting for a reason and purpose knowingly foreign to the administration, to which was added here the element of intentional punishment by what was virtually vocation outlawry. So the Supreme Court of Canada spoke in 1959. Wow, that's a tough one. Yeah.
Why wasn't this mentioned with the change to the municipal elections? It's the same sort of spite, the same sort of signaling. Because Ron Carlin was he was the little big did this too, right? It was a Jewish liquor store.
Yeah, exactly. Yeah, good question. Okay, so what is the tort we're talking about here? Well, we describe it this way: the tort of abuse of power or misfeasance in public office. Kind of different ways of describing the same thing. These, of course, are going to be rare. So we have the O'Dobby estate and Woodhouse case from 2003, relatively recent. So this case did a full canvassing of the origins of the tort of misfeasance in public office. So we'll go down to the second last bullet. These are really the elements that you're going to have to prove in order to establish that there's been a tort of misfeasance of public office. So number one, was the conduct engaged in deliberate and unlawful? Deliberate and unlawful. There's got to be some kind of intention shown there. And was the person who did the conduct aware that it was unlawful and likely to harm the plaintiff? And the Supreme Court of Canada actually in that case said, yes, those elements have been established and the pleadings should not have been struck. The pleadings were actually valid. So we have this other avenue towards liability and damages, and that is wrongful state action that's founded on a charter breach. And we know that the charter, if you can demonstrate a charter breach that harmed you in some way, you can get damages under the charter, under section 24.1. So here we have a case where the person was, and we'll talk about what happened in the case, a person was subject to an unreasonable search under Section 8 of the Charter, and they were awarded monetary damages under Section 24.1. This is going to be pretty rare. So this is the Vancouver versus Ward case, 2010. The pie case. You guys know about the pie case?
Yeah.
So this is the guy who threw the pie at the Prime Minister. At the time, Jean Chrétien threw a pie in his face. You guys remember that?
Yes.
Some of you do, yeah. So what do you think the cops did to this guy when they, grabbed him? He was in a crowd. They grabbed him right away. Mr. Ward was not treated very gently by the police. Throw a pie at the Prime Minister. You gotta pay a price. Of course, they arrest him, put him in handcuffs, throw him in the car, and here's where they went a little too far. They did a strip search on the guy, and the court ends up saying, you went too far. That's an unreasonable search under the charter, and you harmed Mr. Ward's rights. You actually did cause him harm. That was not trivial. So we talk about Ward. It's one of the very first cases where charter damages were actually awarded, even though there was no other underlying tort. So the court says, yeah, you're entitled to a remedy, but we have to fit within these words the appropriate and just remedy. And the court says there's 4 steps to determine whether or what kind of monetary remedy is appropriate and just. So here are the steps. 1, was there a charter breach? Here, obviously, there was clearly a charter breach of Ward's Section 8 right to be free from improper or unjustified search. Step 2, The person who's asking for the damages has to show why the damages are just an appropriate remedy, having regard to whether they would fulfill one or more of the related functions of compensation, vindication of the right, and or deterrence of future breaches. So you're also looking at, should the court, and you would want to argue this, send a message that this kind of abuse of a citizen's rights will be unacceptable to the court. Sending a message. You can't get away with this kind of behavior in the future. So if you can get over that step 2 hurdle, you go to step 3, where kind of the onus shifts back to the state, the government. The government has the opportunity to demonstrate. There are other factors that would render damages not appropriate, inappropriate, or unjust. For example, would this individual have other alternative remedies for the harm that was caused to him? And also, can the government say, well, if you hit us with a damages penalty, we have to pay this guy damages, would that interfere with good governance, such that damages should not be awarded unless the conduct meets a minimum threshold of gravity? So you're looking at an ability of the state to argue that damages are too extreme of a remedy in this situation. If the state can't, rebut that, and they can't get themselves argue their way out of a damages award, then now finally at step 4 we come to, well, how much damages would be appropriate? And the court says, well, there has to be a meaningful response to the seriousness of the breach and the objectives of Section 2401 damages, 2401 of the Charter. We have the compensation goal. So restoring the claimant to the position he or she would have been in had the breach not occurred. Kind of hard to measure that. Vindication and deterrent goals, rationality and proportionalities. They put all these fancy words around it. You have to take into account the public interest in good governance, the danger of deterring governments from undertaking beneficial new policies and programs, and the need to avoid diverting large sums of funds from public programs to private interests. So if it's $10 million, let's say, to pick a crazy large amount of money, you would say, well, that's a lot of money that's now not going to be used to benefit other people in other programs, maybe people who are in need, that kind of thing. So we don't want to go too far in taking money away from other legitimate good causes. Okay, so this is kind of a wrap-up slide. I'm not going to go back through it. Kind of a reminder of some of the high points of tonight. And we're done. Congratulations, you made it. We made it. Okay, so all good, important stuff for you to dwell on, think about for the upcoming exam. We're still a fair ways away. Do we have a date?
December 18th.
December 18th.
Wow.
At 9 o'clock in the morning.
It's you?
So it's the perfect time. 9 a.m. We have 2 more classes. Yeah. So you're really going to be sick of me because we have 2 more in a row, I believe. So I'm happy to jump into a question, a substantive review question. I think a good thing to do tonight, I do have a guest speaker coming next week. She just confirmed. She's somebody who, her name is Val Jepson. She's the current City of Toronto Integrity Commissioner. You guys don't even know what that is. Well, she's going to tell you what it is. She makes sure that city councilors adhere to the conflict of interest and integrity rules. So she's kind of like an administrative tribunal. She's a DM, and she does investigations, sort of hearings. But her term is coming to an end now. She used to be at a different tribunal, so she's going to talk a little bit about her experience as a DM and a little bit about judicial review and things like that. So really more of interest's sake, for interest's sake next week. So do you guys do you have the energy to do it? You want to put it off to next week? What do you want to do? Nobody has an opinion. What do you think? Should we do it?
Is it from the NCA?
NCA, yeah, so it would be NCA question 1. So we could do similarly to, in a similar fashion to what we did that previous class where we tackled the procedural fairness problem. We can do that tonight. I think we can do that tonight. Why not?
Yeah.
Let's jump on it. Okay. So it's question 1 in the NCA. What about Martha Muffin?
I have a question about the exam. What's the structure of the exam? Or is that something that we're going to talk about later?
I think we'll talk about that later.
Okay.
Yeah, I will definitely talk about it to get you guys a little bit, take away some of the anxiety about what it's going to look like. I don't mind describing it in general terms that way.
Yep.
Happy to do that. I haven't submitted it yet, but I have an idea of, kind of the way I approach it, which I'll talk about. So for tonight, and for this problem, let's split you guys into groups. Lost a couple of people, but 1, 2, 3, 4, 5.
Bigger groups,
18. So 6, like groups of 6. 1, 2, 3, 4, 5, 6. 1, 2, 3, 4, 5, 6. And the back people. So let's do 3 groups. Pick a leader at the outset. Read the question. Let's take a good half hour. Again, have somebody as your leader who's going to kind of take notes and then speak for your group. Okay? Right. I mean, you don't have to do this in an exam, but it could be helpful if you to take a few minutes. You're going to get a story about people you've never heard of, a DM you've never heard of, a statue you probably never heard of. So take a few minutes to read the question, reread the question, and then identify who the players are in this story, because it can help and keep you from getting confused about referring to the wrong person or the wrong party or the wrong company, whatever. So why don't we take a minute to do that, to do just that. So who are the people / companies involved here? People / organizations. Martha Muffin. Okay.
Martha and her union.
Separate, but yeah. So we have Martha Muffin. Does anybody get that joke?
Yeah.
Anybody old enough?
Yes.
Sorry.
Welcome.
So in the 1970s, there was a band called Martha and the Muffins. And they did a song called Echo Beach. Great song. I don't know, Martha and the Muffins, Martha Muffin. Thought maybe you'd heard of it. You've heard of it. Yeah.
I could sing it for you, but you don't want me to.
Okay. So who's Martha? She was in a band. Who's Martha?
Very angry.
How do we describe her?
Disgruntled baker.
Sorry?
You're going to say applicant.
Applicant? Yeah. But in more real life terms, what's key to know about her?
She's an employee.
Yeah. Employee. What happened to her? Sorry, my hearing is terrible. Louder, louder. Yeah. Fired. Off the ground, yeah. Yeah. What did the union what's her relationship with the union right now? She's a member. More specifically, what did the union do? Sort of with her?
The union represents her.
Magic word?
Green.
Grieved. Yeah, the union grieved on her behalf. Okay, so we've said what we need to say about her. So who else, for the moment, who else is involved?
Just the other players?
Yeah,
Arbitrator.
arbitrator, okay.
This whole case.
What, how else do we describe you, labor arbitrator? What? Sorry? Yeah, DM. Yeah, and you know, that's why I like that short form, whatever they're called, whatever weird title they have. They're just the DM in our world. Yeah. Who else?
The company is called
Okay.
case.
Yeah. Or short form, SCL, Stones and Case Limited. And, yeah, they're the company. And what else do we call them?
Employer.
Yeah. Not much else to say about them. Who else? A union. So we already know that, yeah, they grieved. And
They also agreed on the list of arbitrators.
yes, they did. But that seems to be thrown in as one of those distracting facts that probably isn't that important, but
What's the matter to arbitration?
yeah. And what happened to their arbitration?
And then they
Well, what happened in the arbitration?
They lost.
They lost, yes. Lost. And now they seek JR. Yeah, okay, so now we've got them firmly positioned. We know exactly who they are, why they're important in admin law. They're bringing the JR. There's a couple of other players who are not all that important, but kind of important. Who are we missing?
Ralph Biscuit.
Ralph Biscuit. Can't forget Ralph. It's all about food. Cakes, biscuits, muffins. A lot of baking happening here. Not much to say about him, right? Like, he's the employee that was compared to her and was found to have seniority. And one more player in this story. Court. Manitoba Court of,
New Brunswick.
no, what is it? NB, New Brunswick Court of. Does it say there?
Queen's Bench.
Queen's Bench. They're doing what? Yeah, they're hearing and deciding the general, yeah. Yeah. Okay. So we've identified the parties. Beautifully done. Okay. Color. All right. So what did you guys do next? Well, what's the question being asked?
That's the judgment.
Write the judgment. Oh, God. I'm not going to make you do that. Okay, we're going to sort of forget that part. Okay, so following our template framework, so who did the shortcut method first? You did. Okay, that's cool. Who did it second? What did you guys do, first or second, or you didn't bother with the shortcut?
First.
You did it first as well, okay. Yeah, it doesn't matter, but remember I said strategically, you may want to do the full-blown SOR analysis, so start here with a Dunsmuir two-step test. You may want to do that. It's okay to do, and I know why you would want to do shortcut first, that's fine. And if you're confident, yeah, I've got time to do this, yeah. If you're worried about time, more important to start with a Dunsmuir two-step test. You do a good job there, you do a full analysis there, you'll do quite well. If you just don't mention the shortcut, but if you did the shortcut only, for example, that could put you in a worse position. So don't do that if you're worried about the time. So why don't we go with the shortcut first, since it's on our outline first. So how did you approach it there? Yeah, you went through the correctness categories.
You concluded that it's not a constitutional question, that it's not a true question of jurisdiction, that also does not draw lines of the jurisdictional lines between juror law and specialized criminals. In relation to point 2, we thought that it might be a general question of law that is of such importance to the legal system, but that it's not outside the adjudicators' specialized area, so it would not fit into that topic. And then we'll jump to the reasonableness, and they concluded that it a question is first the interpretation of the statute.
Right. So a question of law, a question of statutory interpretation, we thought.
Yeah.
Okay. That sounds really good to me. Let's step back though, and and maybe this will be helpful for you guys. Let's describe the question. What question was the DM deciding?
She was an employee.
Sorry?
If she counted as an employee in terms of the collective agreement or not.
In terms of the statute.
Yeah.
It's the meaning of employee in the statute.
The meaning of employee and whether, yeah.
Whether it's only part-time or full-time.
Yeah. Does employee include part-time and full-time?
Or it's just.
Or does employee mean full-time? So yeah, I think you guys are right that that's a question of statutory interpretation. So that's good. So let's spend a moment when you see these questions, say, what is the question the DM is deciding? Because remember how critically important that is. So describe it. Explain the question. The question here that this DM was deciding was the word employer in the statute. Does it include full-time and part-time employees, or does it really only mean the narrower meaning, which is full-time employees only, right? I mean, I explained it the way I just did. You guys could explain it maybe in a little bit different words, but you get the essence of what the question is. There is only one question here, right? Thank goodness. Yeah, there's only one question here. But yeah, I bring that up because sometimes you could get a scenario where there are two questions. And remember the other kind of scenario where it was like, well, did so-and-so reach the road? We'll go back to our jockey. Did the jockey cheat in the horse race? Yes or no? If no, great. Jockey's innocent. If yes, the jockey's guilty of cheating, based on the evidence, what's the appropriate penalty? Is it a reprimand? Is it a 1 week suspension? Is it a 1 year suspension? Is it a lifetime ban? Right? So those are two questions, and you got to watch out for that because the DM there is deciding two questions. Here, clearly only one question. And I think those who said that was a question of law, or more specifically, a question of statutory interpretation, the meaning of the word employer in the statute. That's right. This is a question of law, specifically statutory interpretation of a word in a statute. A very, very common kind of question that a DM decides. Did anybody think it was mixed fact and law? Yeah, it's a legitimate kind of way to think about it. Because in a way it's like, well, employer means only full-time. So then we take that to the facts. Oh, fact, Martha was part-time. And yeah, anyway, you get what I'm saying. So some would argue this is mixed fact and law. I kind of think it's more straight up statutory interpretation. But you can look at it both ways. You wouldn't be wrong either way. Mixed fact and law, question of law, statutory interpretation, probably all an okay way to describe what question the DM was deciding. But this is really important. Break it down, look at it, read it carefully. What question is the DM deciding? Because we know the way you characterize that is huge. Because it's going to get you well down the path of this whole analysis, where it's going to take you to reasonableness or correctness. Okay. So that was so based on the shortcut, yeah, you guys, I think from what I heard, you did it appropriately. You started off with correctness and you said, well, can I fit it into correctness? Yeah, can I fit this question that we just described into the correctness categories? 1, no. 2, we'll pause on that. 3, no. 4, no, right? Nobody thought it was a true question of jurisdiction because we know this DM, this arbitrator, can decide this question. That's what they do, right? They're looking at the statute, meaning of the statute, meaning of the collective agreement, the language. So people, did anyone have trouble with point 2?
We talked about that.
Question of general law that is both of central importance to the legal system as a whole and outside the adjudicator's specialized area of expertise. How did you break it down? Did anyone think it was a question of general law that is of central importance to the legal system as a whole?
I think.
Yeah? Yeah, why?
Because it's like the meaning of employee could impact other areas, not only the employees.
Meaning of employer? Yeah.
Not only bakeries, but other industries.
Yeah.
Other industries. But look, okay, I like the thinking there, but important to the legal system as a whole. As a whole. Outside employment law, does anyone care?
No.
Nobody cares. Yeah. So I think that probably, it's an interesting angle you took, but I think probably the better answer is no. It's pretty specific to labor arbitration, employment law. But I think you're right to say that, you know what, this could apply outside the situation, yeah. So you make a good point, but the Supreme Court chose their words carefully, and they talked about the legal system as a whole, probably because they didn't want people saying, well, legal system, that means, the legal employment law system. No. They're trying to say, across areas of the law. So it's a pretty tough category to get yourself into. But we know courts have used it all the time to find a way to fit it or not fit it. Anyway, so good thinking there. Probably the better answer is no. Let's say it was, remember, with the second hurdle, right? Outside the adjudicator's specialized area of expertise. Did anyone think this question was outside the labor arbitrator's area of expertise? Not a chance, right? Not a chance. Labor arbitrator meeting of the employee, wow. It's, that is right in the middle of, right at the heart of their expertise, employment law, right? Labor law, employment law. So it fails. It probably fails both. For sure fails the expertise element. So we're not looking at correctness. We're looking at reasonableness. And what do we have here? Interpretation of the statute. Statute closely connected to its function. Yeah, you could probably get it in there quite easily, which would lead you to reasonableness. And there you go. There's the Smith shortcut approach. Okay. And remember, we don't stop there. We go on, we say, well, okay, we better make the majority of the Supreme Court judges happy, right? Because most of them are going to say, you must do the Dunsmuir two-step test. They say, okay, I'm going to do it. So how do you start off? Okay. How do you, so yes, question one, how do you answer this question? Does the jurisprudence determine in a satisfactory manner the degree of deference for a particular category of question? There's nothing here. Yeah. So we'll call it the Dunsmuir. We have nothing. We're told nothing, right? We're not going to go do our own research. We're not going to go out there. We probably know intuitively there's a boatload of case law. It says labor arbitrators entitled to deference, probably more than any other DM in the country. But we're going to pretend we don't know that, because it hasn't been given to us. I can give you a case. I could say there's a case, make up a case, or what have you. So then you will have something to look at, and you'll decide whether you think, is this current enough? Is it relevant enough? But if I don't give you anything, and these people, the MCA gave you nothing, so you have nothing, so your answer to one is no. And even if we did have something, we would still go on, right? Because we want to keep the Supreme Court happy. Because I want to see that. No, you want to keep your professor happy. Your professor's going to want to see it. Okay. So now we're doing the SOR analysis. Of the factors, the four factors. So first factor. We have anything?
Yes, there is a privilege.
We do?
Yes.
You're right, we do. Okay. So 1, privative clause. What do we have?
Yeah, so it's an arrow.
We have a, how would we describe our, what does our privative clause say?
That the provision is final and binding.
That what is our?
The provision of the arbitrator is
The decision.
final. Yeah, decision is
Yeah.
final and it's binding.
Yeah, the decision of the DM is final and binding. How would we describe the strength of that privative clause? Strong.
Clear.
And this was in the intent for national courts.
Strong. We use strong, weak. That's the terminology we use. This is final and binding is about as strong as it gets. Let's say it just said final.
I think it's a
Bill was so strong.
Yeah, it's also strong, but it's maybe not as strong. Because you'd say, oh, why didn't they say binding? They dropped binding. Oh, the legislature was signaling something there. So maybe it's not that strong. Maybe it's an 8 out of 10 as opposed to 9 out of 10.
How would we cook? A weak primitive clause. How would a weak cook?
I mean, wouldn't you interpret final itself as meaning they don't want the courts to get involved in this? So
True. Yeah, so if they use the word final, yeah, that's a privative clause.
yeah, but in terms of the strength,
Yeah.
even if they don't use the word binding, I would imagine it means the same thing. It's just redundant for them to use the word binding there.
You could argue that. There's a tradition of that phrase, final and binding. So you might say, oh, why did they drop that word? Must mean something. But we're arguing over a very fine point. I think they would both be strong.
So what is it weak?
What is a weak privative clause? I'm trying to remember. Anybody? I'm trying to remember the examples in the textbook. Something like, the arbitrator shall decide the matter. Say that. Shall decide the matter. So it's a little bit of a, okay, they're saying the DM, has the last word, but whoa, why didn't they use the standard phrase that's used all over Canada, all across Canada, final and binding or final? So there's something to that. So you would say, okay, I guess that's a privative clause, but it's not super strong. It's probably a medium or weak privative clause, something along those lines. So some other thing that says, that the DM makes the final decision, something like that, makes the decision. Not always easy to determine the weight, but for your purposes, knowing that final and binding is the classic strong privative clause, anything that's a bit different from that is going to be questionable, right? And maybe not as strong. Okay. So, yeah, we talked about arrows. What arrow do we have here? Strong privative clause, up. Arrow up towards. Yeah, towards reasonableness, towards more deference. Exactly. Don't say there's an arrow up which means reasonableness. You may look at me and say, well, what's wrong with that? But we want to be careful about our language because we don't say it that way. We say the arrow points towards reasonableness, or this factor points towards reasonableness, not it is reasonableness, because that's conclusive language. We stay away from that. You could say it points towards more deference or suggests more deference. That's totally acceptable too. You're saying the exact same thing when you use that language. Okay. 2, what did we say about 2? And what's the sort of magic phrase the Supreme Court told us to use here? Purpose of the tribunal. As determined by enabling legislation. There's a phrase that comes into play here. Yeah, discrete and specialized regime. Can we say that the enabling legislation for the arbitrator here, can it be described as a discrete and specialized regime?
I got confused here. Like, are we talking about this specific arbitrator who was now?
No, we're talking about this, labor relations regime. What's the New Brunswick Labor Relations Act? There's an arbitrator who's exercising powers under the New Brunswick Labor Relations Act. What do we think of this act? Could you describe this act as a discrete and specialized regime? No.
It's not for specific kind of.
You think it's general? You think it's general? Anyone think it's specific? Yeah, this is a tough one. So the way I would look at it, at this question, and the way it has been looked at, is, labor relations is a specialized area of law. There's a specialized regime. They only do labor relations. Now, granted, and what may be causing you to think a bit differently about this is that, labor and employment law is a huge area of law in Canada, right? And in any province. It's a big area of law, but it is specialized. They kind of do one thing. They deal with collective agreements, and they deal with the issues that arise under the Labor Relations Act. That is specialized. You can describe that as a discrete and specialized regime, that being labor law. With people called arbitrators who are labor specialists, right? Labor law specialists. Anybody disagreeing with me? You're allowed to. To me, this does look like a discrete and specialized regime, albeit a big one.
We were just a bit confused by last week when we discussed that if we have a tribunal of professionals, where we have lawyers, doctors, engineers, etc. So labor law covers mining industry, cinema workers, whatever, like bakers. So
yeah, but it doesn't cover all those. It covers specifically the employees of those industries, for example, those industries.
But
Not everybody is covered under that. That's why it's specialized.
Yeah, but
right?
colleges also that would be specialized because of college professions, because that would cover just the disciplinary hearings of all the professions, but it's still just a disciplinary hearing. Isn't that still specialized? So.
Yeah, no, I see your point. I think, what we're talking about here is the relationship between employers and employees. There's basically one law for unionized workplaces, Labor Relations Act, So it's pretty specialized. I understand why this isn't easy. But it's about employer-employee relations. There's kind of a single body of law around employer-employee relations, collective agreements. There's a specific kind of set of rules, set of law, and it doesn't matter so much whether, it's an employee who does baking or an employee who does mining or an employee who does, something else. It's about employer-employee unions. So it is considered to be specialized. I see your point. You say, well, it's covering all these different industries. That's not very special.
We have to analyze whether it is relevant for the tribunal. It's that the specialties of the industries are relevant when whatever is being decided. Because in the disciplinary hearing, it would be relevant of whatever happens in medicine, whatever happens. Like the legal.
Yeah, I guess, and this is hard, but I think in the labor relations, labor arbitration world, there's kind of a single set of rules around collective agreements, what's in the statute, whereas regulation of lawyers versus regulation of engineers brings up very different kinds of issues with different special knowledge needed. But I take your point, because they do cover. This labor arbitrator, agreed. One day could be working on employees who bake, and then employees who work in a mine, and those are different kinds of jobs. So, yeah, good point. So, there's some room for debate here, and but I think you would agree with me that they're not. Like, remember, I picked an extreme example of like a super tribunal that hears. Complaints from all DMs in Ontario, let's say. Remember, I think I even told you guys, in Australia, they have this super tribunal that literally hears every appeal from every tribunal.
Well, similar would be.
They're the least specialized that you can imagine, because they deal with every single kind of subject matter. Professional discipline. Environmental approvals, like all these things that are like, you would say they're not even related. They're like different worlds.
Wouldn't you say that it's like a court, pretty much?
Yeah, where courts have to be generalists often, and some courts specialize, but most of them don't. You're right, and they're quite general. They don't have specific expertise. So, I have the benefit of knowing that the courts have said time and time again, labor arbitrators, they work under a discrete and specialized regime. So, remember that, think about it in your case. But often, there's debate here, legitimate debate. Well, how specialized are they really? And don't they deal with kind of a range of issues, this kind of thing? But certainly the best answer here is to arrow up, pointing towards more deference, pointing towards reasonableness. Again, because it's specialty in labor relations. So it's somewhat specialized. Although, again, I hear you can argue, well, I'm not convinced it's super specialized. I can imagine a scenario where there's greater specialization, greater expertise than all labor law. So big, so broad. You make a good point. Okay, so yeah, this is hard, isn't it? But remember, the factor that's going to have the most weight, and pretty much all of the Supreme Court of Canada agrees with this, is our next fun factor. Nature of the question. So the great thing is we've already done some heavy work here, right? We because we did the shortcut approach first, we described the question quite well. We mostly think it's a question of law, in particular a question of statutory interpretation. One could argue that it's mixed fact and law. Statutory interpretation. So I say mixed fact and law, maybe. Having categorized the nature of the question the DM was deciding, again, what would you guys say? Where's our arrow going? Because we're using arrows now. Yes, up there. Big up. I mean, you can also add the fact that the arbitrator's determining a question of law, of statutory interpretation, right within their own area of specialized expertise. They're not going out there and saying, oh, I'm now going to look at the Human Rights Act and look at a provision there because I think it's important. You'd say, wow, they seem to be wandering off, out of their little home turf there, and they're going off into some other statute. And you'd say, I don't know, they're starting to get away from their expertise, but not here, totally not here. So you would want to add that and say, yeah, a big arrow up, because they're interpreting a question that's right in their wheelhouse. What's the meaning of the word employee? Who better than a labor arbitrator to say, I know what an employee means, as written in the statute, in the collective agreement. That's an easy question for me as a labor arbitrator. I don't have to work very hard at all. I know this in my comfort zone, okay? So you're gonna get a strong arrow up, and we know, and remember this, and you should tell me when you're going through these, oh, by the way, factor 3 usually carries the most weight. So, this arrow going up is, it's got a lot of power and can really drive the answer more so than the other 3 factors. Okay. And for expertise, even though we've already touched on it, the court wants us to do it again. But in a more in-depth way about who are these people, not the individual, right? We don't look at this DM's resume, how long have they been working, and where did they go to school, and what's their training. No, we don't do that. What do we do?
They had a list of 13 DMs that they agreed on, and they selected this DM from this list. So,
yeah, so the DM was on a list, like a pre-approved list, right? It appears. So yeah, that's a valid point to make. But more generally, what would we say about a DM like this? A labor arbitrator. Generally speaking, what can we say about those types of people and their expertise on a question, a labor question, labor law question? Yeah, they're generally going to be considered to have high expertise. This is not a lay person. This is not a generalist. This is someone who we can safely assume has expertise in deciding a question like this. Pretty straightforward, fairly easy to say that this tribunal, this arbitrator, is not really a tribunal, has expertise. Okay? If it was a human rights tribunal, there's a bunch of DMs within that. Again, you look at the human rights tribunal as a whole and you say, yeah, these people, these decision makers at the human rights tribunal, we can safely assume they have expertise in human rights issues. We don't have to go too much deeper than that.
So based on factor number 4, almost always they will be pointing upward towards more deference because every DM has the expertise in the question they're deciding, isn't it?
Well, no. It's okay. It's a good point because it seems intuitive that they will always would. But remember, again, let's take our generalist DM, who's like a appeals DM, who just hears appeals on everything and anything. What would you say about them? Are they really? Are those people really specialists? Probably not. They'd be generalists. Like you made a good point. You brought up judges. Judges are classic generalists. All right, give me a case. I'll do a criminal case this week, and next week I'm going to do a contract law dispute. And then I'm going to do a JR. They do that. A lot of them, they do other stuff, and then they sit on and they do a JR. So they have civil law, admin law, criminal law, all within the same month. These guys aren't really experts, are they? And the one I described, that really vague, we hear appeals from anything. Any DM, it all comes to us. We're smart people, we know admin law, we can figure it out. Well, no, they're not going to get a very good arrow here. In fact, they're probably going to get an arrow down. So it's possible to get an arrow down. But yeah, in most cases, the arrow is going to go up pretty easily. Or sometimes you're going to get something in the middle where they have a bit of expertise, but you're going to say, it's still pretty broad. Their area is still really broad. And they're uncomfortable, and you may be uncomfortable saying, yes, these people are very expert in that field. So you just got to go with what you're given. They don't give you a whole lot here. So a lot of it has to be inferring. And if you're inferring or making assumptions, just tell me. I'm going to assume this arbitrator, like other labor arbitrators, is expert, knows employment law, knows labor law well. So typically they're going to be, or I'm going to assume they have expertise in a pretty specific area, which is labor law, so I'm going to put the arrow up. Or if you have a problem and you say, I'm not so sure, again, tell me, give me your reasons why you think, well, I don't think they're so expert. I have a problem with giving them a nice big arrow. I don't think it's justified. Just tell me why. If you can justify it, great. Because remember, when you go to court and you're arguing, one side's going to want an arrow up and the other side's going to want an arrow down. So they're going to find creative arguments like a bunch of you have brought out tonight to try to get the arrow down maybe. But we know we're kind of being objective here. We're actually the court, right? Being objective, I think we came up pretty solidly on 4 arrows up, 4 big ups, 3 is a big up. Maybe let's give it another arrow. Just show how strong it is. It's double. It's like a double whammy. So we have no trouble concluding what? Yeah. So are you going to just say, okay, reasonableness? No, what are you going to do?
Apply the applicable standard?
No, but even before that, yes, we're going to apply. Even before that, what are you going to do? Don't assume I know, just say, yeah, reasonableness. Give me a little more, sorry, keep interrupting you.
Kind of repeat everything that was said before
Yeah.
in one paragraph.
Yeah, go back, look at the arrows. Say, I've got all arrows up. Maybe mention that, by the way, factor 3 is pretty strong. Obviously, it's a solid arrow up. So I have no trouble concluding the applicable standard of review is reasonableness. You don't have to repeat everything you already just said, but do some kind of summation for me so that you wrap it up for me. And again, don't assume, oh yeah, well he knows, he gets it. Like, just tell me like I don't know. Okay? Just tell me. and explain a little bit why you think it's reasonableness. You may have arrows down, in which case, you're going to have to do some work to explain why reasonableness. This one was really easy. But we could have some arrows down, or even sideways, and then, you might have a bit of a challenge. But yeah, good work, guys. So of course we're going to, and I know it's getting late, and maybe we can go back over it next week, but you're going to apply reasonableness, of course. And yeah, applying the appropriate standard of review. We know it's reasonableness, so we know we have to do that double test. We got to look at process and outcome. When it comes to process, what are we looking at again? Reasons, yeah, very good. What are the reasons here? Pretty thin.
Almost no.
Oh, yeah, there's not much there, but to be fair, we don't, in reality, the adjudicator probably would have written, 10 pages or something. There are reasons we don't have much to go on. And I think you'll say, look, I don't have much to go on, so it's going to be hard for me to show that there's justification, transparency, and intelligibility. Because, unfortunately, from what you've given me, I don't really know why the arbitrator decided what they decided. I'm going to have some idea. Because there's this thing about, they said, employee must mean a person who's covered by the collective agreement. She wasn't covered by the collective agreement when she was part-time, so boom, there's your answer. Logic to that. So you're going to say, here, probably, I don't have a lot to go on, so I have a hard time saying that the reasons were justified, transparent, and intelligible. I have a hard time with that. And try to apply all three of those words, right? Were they justified, transparent? In other words, did they put all their thinking out there for you to see? And do they make sense? Is it intelligible? Logical is another word you could use. So that's what you're going to do. And of course, we also have to look at outcome. What did you guys say about outcome?
It was It was between the ranges of outcomes.
Within the range of outcomes. Okay.
I have a question about that.
Yeah.
Just in general, not for this question only, but
Yeah, we're going to need to talk about that more. Because
if you have a range of outcomes, here it was either a yes, no.
yeah,
She is or she isn't.
yeah.
So does the idea of range of outcomes necessarily, does that sort of apply to things where you've got a wide thing, or does
Could
it-
apply to anything. It could apply to yes, no.
Okay, really?
Black, white, yes, no. Here, you could argue, this is up to you, this is what makes it great. So you could say, I'll do this quickly, I know I want to go. You could say, okay, that's my personal range of acceptable outcomes. And in here I've got yes, and I've got no. Polar opposites. They're both cool. They're both reasonable. But the person next to you could say, no. I have a different range of reasonableness in my personal opinion. Draw the same circle. Yes is here. And the answer here was no, right? She's not an employee. No. No is unreasonable. It's totally unreasonable. It's outside what I consider an acceptable outcome. That's just flat out wrong. And if you looked at it and you said, this outcome to me is, I'll use the word, nuts. I don't like it. I have a hard time with it. I think it's bizarre. I'm using words like that to explain what your thinking and feeling is. And I think this is so unjustified that poor Martha, started before Ralph got screwed, you know, you're going to make a case that this is unreasonable, and if you explain it that way to me, and you say, this is my zone of reasonableness, the only reasonable answer is yes, no is unreasonable, boom. The DM's decision must fall because it was unreasonable. Is that, you know, that's what the DM did. So that's what the DM did. It's unreasonable. So you guys draw your own circle around what you think in your mind is reasonable.
The problem of saying that no is unreasonable is that you're basically doing practice analysis, saying it is reasonable.
You're right. That's what judges and lawyers and academics are arguing about, and they're saying what you said. Well, that's really correctness. But no, this is what the court does. It draws its zone of reasonableness and it decides where each outcome is. Whereas correctness, we know, is, well, there's a right and a wrong. There's no zone. So you can't have this in correctness. This doesn't work at all in correctness because only one of those works and one doesn't. That's correctness, right? So again, here, you might say, personally, I don't like the no. It bothers me, and I feel badly for Martha, but I can't say it's unreasonable. There's logic to the outcome. So I'm going to let it go. And that's what good JR judges do, is they draw that zone in an appropriate way, and they don't say what they would do. They just say, well, can I say this is a crazy outcome or not? No, not a crazy outcome. Okay. Again, even though this is the judge talking, well, I wouldn't have done this to poor Martha. I would have saved her. But I'm not going to interfere because this is a labor arbitrator that deserves respect. And we're not going to go in and, you know, kick the labor arbitrator just because they did something that we personally don't like. That's not right. Respect, deference is about letting this decision you don't like go. And you guys can do that too. You can even tell me, and I've had people tell me, I personally don't like it, but I can't say it's unreasonable. People say that, which is great, because that's exactly the way your mind should be working. And judges' minds should be working. Judges hate doing this. They just hate it. But they've been beaten into submission to do it. And they, you know, for the most part, they're able to do that. But you can see the game, right? You just draw the circle how you want to draw it. Well, I'm going to draw a small circle. That's your choice, right? The small circle of reasonableness is this. So that's the small circle of reasonableness because it says no, the answer no is unreasonable.
You have to do that in
Draw a circle? No.
I don't know, this is stuff, I don't know if you can do it to this, it's not like, no, right?
I've had people do it. You don't need to draw a circle. Just express it in words. I think the answer the arbitrator gave here is outside the zone of reasonableness. It's unreasonable, and use this language. You must use this language. Don't go off on a, I don't like it, it's not fair to Martha. Don't do that. It's just, the reasons suck, if you're saying, they're no good. Or the reasons are fine, but the outcome is unreasonable because it's outside the range of acceptable outcomes because, just say something. It's unreasonable. I think they've stretched the meaning of employee, or they've narrowed it. Here, the arbitrator did this narrow interpretation of employee, and you would say, that's just unreasonable, an unreasonable failure to recognize, the important contribution of part-time employees or something. Just, give me something. Or you're gonna, go up on your soapbox and tell me what you think. In the case where you don't like it. In the case where you like it, it's harder because you just have to say, well, I agree. So, yeah, that's for you to do, and that's what makes it fun, because you can do your own thing. I can't tell you that your opinion is wrong. Your opinion is your opinion. So we all could have come to a different conclusion here. That's totally fine. No, we all have to come to the same conclusion that it's reasonableness, not correctness. But apart from that, I can see us having a nice little debate here about where you personally would go. And as long as you are disciplined and stick to that language, you're good. You can do what you want. Because that's what judges do. They do what they want. But they use that language so they don't get whacked on appeal.
So everything that we did in step 1 of Dunsmuir cases, the four things, like has nothing to do with how the circle looks, so whether the circle is bigger.
Step 1 of Dunsmuir? No, what do you mean?
Like when we did the 4-step thing, the privative clause.
Yeah.
Like does that affect?
No.
Oh.
That only has to do with, are you bringing reasonableness review or correctness review?
Right.
Because then you're bringing different language.
Okay.
Right? This different language. All this stuff, reasonableness, and then correctness, which is just very basic, as described there. Okay, so that's it. That's good. I know it's hard stuff. I'll find another example we can use.
Don't know more examples for the staff. Yeah, the purpose of the tribe.
Yeah, no, that's a tough one. Yeah, maybe we'll look at some more examples of that. Discrete and specialized regime or not? Yeah.
We have a question where we carry out a substantive review and then we talk about the remedies.
Don't talk about remedies unless you're asked to do that.
Yeah, I guess I'm wondering if we'll be asked to use that.
Maybe. I can ask you whatever I want. But I will tell you, I will undertake to you that, I stick to the slides. I'm not going to go hunting in the book for something I never talked about. Okay. I will not do that.